Cody Jordan with the Public Defender's Office.
All right, the first file I have here is that of Arucha Brown. All right, All right, the Office of the Public Defender is hereby appointed, and we have a couple of cases here. First one is grand theft, third degree of a motor vehicle. Bond is $1,000. And that's Division 14. Public defender is appointed. And then as to the second charge of no valid driver's license, that's Division A, public defender appointed. All right, I believe that's everything in regard to this defendant.
What was the bond in the traffic case, Your Honor?
Oh, that is $500.
We'd ask that that be treated as a subsidiary charge to the main charge of...
No objection.
So ordered.
Hmm?
All right, your name, please?
Charles?
Kristen Anderson refused.
All right.
Is it the first time?
All right, now in regard to this matter, let's see, we had a medical absence, and there's also an order here that fingerprints needed to identify the defendant.
She has been correctly identified.
Say again?
She has been correctly identified.
All right.
This was the case
As
that was
Monica.
reset from Wednesday?
She
because
is,
didn't-
she is Monica, but she used Kristen.
Okay. Your Honor, we would ask that the case not be rolled again. It was rolled from Wednesday so that we could get her fingerprints back because it was a false ID to law enforcement. So we'd ask that the public defender's office be appointed and probable cause be found and it not be reset again.
Your Honor, our contention as to the second case, 2019, and this is still, I'm sorry, we are on Kristen Anderson, 2019 CF 9535. The Public Defender's Office would reject the notion that there is probable cause. There is nothing in the police report to indicate how the false identity adversely affected the person in question, which is what she is being charged with, which is an F3. That is the difference between false ID to law enforcement, which is an M1, a misdemeanor in the first degree, and false ID, which adversely affects the other individual, which is a felony in the third degree. We would suggest that there's only probable cause for false ID to law enforcement, not the felony aggravator.
All right. State's response?
The response would be that the fact that by being arrested under the sibling's name, that gave the sibling an arrest record. That is what falsely impacted that sibling's name and information. Obviously, if that sibling wanted to get her record expunged or sealed based on whatever happened, that'd be more difficult, especially because her sister used her name.
All right. Then, for purposes of this appearance and charge today, there would be probable cause found at this time in regard to giving false name. The bond would remain at $2,000. All right, now, what is Office of the Public Defender's position in regard to being appointed?
Yes, Your Honor. For the record, we will waive her appearance for first appearance.
All right. Public Defender is appointed. We have, on the paperwork here, says Division AGA.
That's James Blankenship, he refused as well.
All right, and the next file is that of James Blankenship.
Your Honor, we'd ask that this not be rolled again. I guess he refused yesterday. So we'd ask the public defender's office be at least temporarily appointed. And since the failure to appear,
We
they
are,
not.
we're already appointed.
Okay, so we ask that it not be rolled again.
Yes, Your Honor. We will waive his appearance for first appearances.
All right. And it would still remain in a no bond status at this time. And we've got, let's see, 2018-1382 case number and 2019-3400. All right. That should conclude this matter for today's purpose. What was the reason? All right, now the, excuse me, next file is that of Joelcon Charles. Is that you, sir?
Yeah.
All right, so you have a case involving trespassing in a structure or conveyance. Bond is $500. I have no application for a criminal indigent status.
Your Honor, we asked this public defender's office be appointed based on his out of bond competency cases.
Yes, Your Honor. The public defender has already been appointed on his out-on-bond cases.
All right,
He is set for competency in those matters, and given that fact, we'd ask Your Honor to take no action on his out-on-bond and release him ROR as to the trespass charge.
State would object to him being released ROR on the trespass. We believe that a competency order and conditional release plan are more appropriate than a straight ROR. And no
Alright.
objection to no action on the out of bond cases.
the court would grant and defer to the state attorney. All right,
Is the bond staying at 500, Your Honor?
yes.
Thank you.
Okay, sir. I'm gonna talk to your attorneys. They're likely gonna file the same thing they did last time.
All right, next file I have is that of Zachary Calkins. Is that you, sir?
Yes, sir.
All right, sir, you've got several charges here: possession of methamphetamine, bond 1,000; attempted burglary of a dwelling, bond 1,000; and criminal mischief, more than 1,000, bond $250. And probable cause does exist. Sir, do you want me to appoint a lawyer for you?
Yes, sir.
All right, Office of the Public Defender is appointed. That appears to be Division 15.
Your Honor, we'd ask that count 2 be treated as a subsidiary charge. And be,
Objection.
All right, so ordered.
We'd also ask for no return to the scene.
All right, that's appropriate and would be ordered.
do you have any questions?
No.
Okay, that's, also. Well, that would be, All right, Karina Canal Trotter, is that you, ma'am?
Yes, sir.
All right, ma'am, you've got a couple of allegations here. Fleeing attempted to elude a law enforcement officer with siren and lights activated, bond, and no bond at this moment, and reckless driving bond $100. Probable cause does exist in regard to this case. I have no request for Office of the Public Defender to be appointed. So, all right,
Your Honor, after speaking with her, she does wish for the public defender to be appointed. We would ask the court to take testimony on the record as to her indigent status.
all right. So ordered. Now, what's the state's position on the fleeing bond status?
We asked for a $3,500 bond, that's count one.
Your Honor, defense is requesting that she be released PTR. She has no prior history whatsoever. She does have community ties. She does live in Orlando, and she's employed full-time. We'd request that, given her lack of history, she be given the reasonable release condition of PTR and stay in contact with pretrial release services.
State will amend, Your Honor, no objection to PTR.
All right. So ordered then in regard to count one, this division 15.
All right, you'll get released. Talk to your attorney.
All right, Jordan Davis.
Yes, sir.
All right, I see no application for Office of the Public Defender. Okay.
In his failure to appear case, he does retain a private attorney. I believe his name is Matthews Bark.
All right, what's the state's position in regard to these charges?
We asked the bond be stated as is, Your Honor. So no bond on the failure to appear, and then 500 and 100 on the attaching tag, and no registration.
All right, without prejudice, there is, at this time, no bond in regard to the FDA, and then attaching a tag, not assigned, 500, and no registration bond, 100. And the Office of the Public Defender, well, under the facts stated in the paperwork here, any objection to the court appointing the Office of the Public Defender?
No, Your Honor.
So ordered.
Do you have any questions?
I just don't understand how I didn't know about the court case. Court date.
I got no idea. Normally, if it's a PD case, I could give you some idea. And bonds, you're not going to be accruing any time in these cases. So for now, contact your attorney as soon as possible. Because you're being held up on the failure there. Thank you, Your Honor.
All right, Kyle Fisher is the next case. Got you, sir? All right, sir. You have a charge, grand theft, third degree of a motor vehicle. Bond is $1,000. You qualify for appointment of the Office of the Public Defender that is ordered at this time. So grand theft, third degree of motor vehicle, bond 1,000, and that is all we have this time. Public defender.
Here, take this bill.
All right, next file is that of Ryan Ladd.
Yes, sir.
All right, sir, you've got a charge here, a grand theft, less than $300, but not more than $5,000. Your bond is $500. You want the public defender appointed to represent you, sir?
Yes, sir.
All right, Office of the Public Defender is hereby appointed, that's Division 19.
Your Honor, we'd ask for no return to the Walmart.
All right, no return to the Walmart at 1700 South Orange Blossom Trail in Orange County. All right, next case is that Jerry Pollard.
Yes, sir.
All right, sir, you have a new set of charges here. Attempted burglary of a dwelling, bond 1,000. Criminal mischief, bond $250. And probable cause does exist. Now, sir, do you want me to appoint a lawyer for you?
Yes, sir.
Office of the Public Defender is appointed. The bond on which a release would be stayed on an attempted burglary of dwelling, bond 1,000, and criminal mischief, bond $250. Public Defender appointed.
We'd ask for a no return to the Eggleston Avenue, Kingswood Manor apartment, home.
All right, that would be ordered as requested by the state. So no return to 5320 Eggleston Avenue in Orange County. All right.
Your Honor. He has an open case.
And no action on the out on bond case.
So ordered.
Your Honor.
All right, now, Josiah Rivera,
Yes, sir.
ma'am, you have a set of charges. Homicide, no bond, and that's murder type, and then homicide, negligent manslaughter, vehicle, DUI, no bond. Moving traffic violation, driving while license suspended, resulting in death or serious injury, no bond, and DUI with damage to property or person of another, no bond. Now, according to your financial affidavit, you do not qualify for appointed counsel. So, what is your situation as to that? Are you in a position to hire an attorney?
At some point in time, yes.
I can't quite hear you.
Yes, at some point in time. I'm working on it, but I have my public defender with me here today.
And Your Honor, as a friend of the court, I would note that she is entitled to bond and conditions of release, as she has no charges which are either a capital offense or a punishable by life offense. Her most severe charge, which is DUI manslaughter, is a felony in the second degree, and according to the bond schedule, would be set at $10,000.
I have count 4 as an F1, not as an F3.
I have count for DUI property damage or personal injury as an M1.
All right, and
May I have-
state again?
May I have one moment, Your Honor?
All right.
And that is the one you're referring to, count 4 DUI property damage or personal injury. Statute section 316.193.
Mr. George, give me 1 second. Give me 1 second. I'm sorry, it's M1, that's my mislabeling it. Your Honor, S2, count 2, which would be the homicide, DUI, cause death to human, that's an F2. State would ask for a $15,000 bond as to count 2. As to counts 1, 3, and 4, no objection to subsidiaries, so therefore 150 on count 1, 150 on count 3, 100 on count 4, no contact with the victim's family. We'd ask for a scram bracelet to be placed on her ankle, and no driving without a valid driver's license.
Your Honor, we would object to the bracelet, and we would also ask that count 2 be set at the bond schedule amount of $10,000, not $15,000. And we'd also note that she has no prior history, no prior criminal history, no felonies, misdemeanors, failure to appears. She has no out-of-state history or juvenile history either, and as such, that is why we would object to the bracelet, as well as request that the bond be set in the normal bond scheduled amount. No objection to the subsidiary charges in count 1, 3, and 4.
All right, with respect to count 2, there would be a bond set in the amount of $10,000. regard to the other condition I'm going to impose, do not operate a motor vehicle as defined by the laws of this state.
Was there a
All right,
request?
we have, in regard to count 1, 150, count 2, 10,000, count 3, 150, and PTR as to count 4. Is
100, Your Honor. It is a misdemeanor.
Count 4 should be $100, Your Honor,
yes,
and no PTR.
correct.
We'd also ask for no alcohol, Your Honor.
That would be appropriate, considering the allegations here, so that would be so ordered. No alcohol or intoxicating type beverages or other substances
Thank you, Your Honor.
without a prescription.
Public defender. I'm gonna give you some paperwork.
Oh, okay.
Thank you, Your Honor.
All right, Raul Cassiano. All right, your name, please?
Angela Riles.
All right, that's Angela Miles. The next case? All right, let's back up here. What is your name?
Angela Riles.
All right. Ma'am, you've got a charge of driving while license suspended or revoked with prior conviction. Bond is $2,500 at this time. I have no, excuse me, I have no application for criminal indigent status. Any input from public defender by way of prior representation or anything?
Your Honor, state has no objection to PTR in this case.
All right. PTR is allowed with a condition you not drive a motor vehicle without a valid driver's license.
Thank you, Your Honor.
Alex Sanchez.
Yes, sir.
All right, sir, you've got, excuse me, in charge here of possession of a controlled substance on $1,000. Check further. And civil infraction of running a stop sign. And, well, let's see, driving with no lights. Now, so, there would be a bond required, and that would be in the amount of 100, excuse me.
Your Honor, we would ask the second case, the traffic case, to be set as a subsidiary charge and set at $100.
All right, granted.
Okay, so once I'm done, I'll put this one and I'll go that one. Make it out. Do I have to come back here or do I have to wait till they give me the court date?
All right, the next file I have is that Alan Singh. Is that you, sir?
Yes, sir.
All right, sir, you have charges here. Grand theft, third degree, more than 300, less than $5,000. Your bond was set by the judge at $1,000. Do you want me to appoint a lawyer for you?
Yes, sir.
Office of the Public Defender is appointed. We have Division 14.
Your Honor, what was the bond as to count two? Oh, I'm sorry, there's two cases here.
Yes, we have grand theft, third degree, more than 300, less than $5,000, bond $1,000, Division 14. And then another case involving grand theft, third degree, more than 300, less than 5,000, Division 12, and the bond there is 1,000. And the Office of the Public Defender appointed. All right, next file is that of Steve Burnett.
Yes, sir.
All right, so you've got a, looks like Polk County warrant for violation of probation. You're in a no bond status as to that case. So you'll be transported to Polk County to answer to the charge there. And then you've got a possession of cocaine bond is set at $1,000. That's an Orange County case. The Office of the Public Defender is hereby appointed. Now, what says counsel as far as the application for criminal Indian status and its effect, if any, on the out-of-county case? or any application?
I don't believe we can be appointed to the out-of-county case, Your Honor, as we do not.
That sounds appropriate, so that would be so ordered at this time. As to the Polk County case, public defender is not appointed at this time. All right, Raymond Walker.
Yes, sir.
Sir, you have a set of charges, it would appear. Attempted burglary of a dwelling, bond $1,000. Criminal mischief, bond $250. Do you want me to appoint a lawyer for you, sir?
Can you repeat that? Yes, please.
What do you say?
Your Honor, I do believe he is homeless. He would qualify for the public defender.
All right, then public defender be appointed now, and that looks like Division 14.
We ask for no return, Your Honor, for the incident.
And a condition of bond would be no return to 5320 Eggleston Avenue in the Kingwood Manor subdivision in Orange County. All right, Elwin Stell?
Still,
All right, sir. Sir, you've got a case involving an out-of-county warrant. Your bond is set at $2,502. It's out of Nassau County, so if you do not post bond, and there's, let's see, another Nassau County warrant, $2,502. So you've got two cases involving Nassau County warrants, 20, huh? All right, I stand corrected. One case out of Nassau County, bond totals $2,502. So if you don't post that, you'll be transported to Nassau County to answer to the charges there.
how long do I have to post it?
Sir?
How long do I have to post it before Nassau County comes?
Your Honor, I believe he can be held 72 hours, not including weekends.
All right, and for the record, any input from the state?
No, Your Honor.
All right, so ordered. All right, next file is that of Keisha Brown, also known as Kersha Brown, also known as Kersha N. Brown.
She refused,
Your
Say
Honor,
again?
refusal.
All right, reset.
Your Honor, we would ask that it not be reset. She refused on 7/2. I don't know what happened yesterday, but this is at least her second time refusing. We'd ask that it not be reset again. She voluntarily made herself absent for the first appearance.
I believe this is her third refusal, but she also had a mental health hold one day.
All right,
So
well, what I will do at this time is to then go ahead and temporarily, at least, appoint the office of the public defender.
And Your Honor, we'll waive her appearance as to first appearances.
All right. And we have the burglary of occupied dwelling bond 5,000, ag assault with a weapon bond 150. And no return to the premises. At 619 Raleigh Street in Orange County. The bond on which she is released at this time would be revoked and no bond. Next file is that of Christopher Fullenwilder.
Refused, Your Honor.
Say again?
Refused.
All right, reset.
I'm sorry, what was his last name? He refused yesterday? Your Honor, this is the second refusal. We'd ask that it not be rolled again.
Your Honor, we would ask this be reset. It looks like it was a behavior, not a refusal.
Yes, we'll do that. All right, David Wayne Hale, also known as David W. Hare.
Yes, sir.
Your Honor, this is a reset for 24 hours for probable cause. I'm going through my email to see what the attorney from yesterday sent an email to Officer, looks like Holiday. And the email response from Officer Holiday reads, an arrest was effectuated on this individual as he came to the police department to get his vehicle. It came to my attention after the arrest that some individuals were arrested for possession of heroin and meth. A few nights previous to these incidences, the arrestee stated they purchased the contraband from David Hare in his room 119. There are multiple supplemental reports. The cases will be turned into the state attorney office in the arrest packet. They did not provide a supplemental report, they sent an email.
Your Honor, we do not have a signed affidavit with this information. As such, we would ask that probable cause not be found. I know the officer in his email states there is supplemental reports, but we do not have those reports, and we do not have anything from the officer in a signed affidavit as to support the conclusion of probable cause. The state was given 24 hours.
All right, anything further from the state?
No, Your Honor.
then at this time, the court would find there's no probable cause to be found, and without prejudice, the state may reallege or refile, whatever, but there's no probable cause at this time. Therefore, there's no requirement that any bond be posted on any of these named allegations here.
Your Honor, we just request the defendant be aware that this doesn't mean the case is dismissed. It just means that he'll be released without having to post a bond today, but to keep in touch with his attorney because the state may file charges against him.
That's right.
Yes, sir.
Absolutely.
Yes, be released on recognizance and without prejudice to the state to file whatever is indicated in the opinion of the state to be addressed by the court at a later time. All right, next file I have is that of Michael Raymond Lavalley. And that too was reset for the state to file something, anything further that's indicated. So, input from the state?
It looks like ASA Switzer sent an email yesterday at 4 o'clock to Officer Simpson, and we did not receive a response back.
All right, then there would be no probable cause and ROR.
Your Honor, my understanding is he has a failure to appear as to one case, 19 MM 3651.
He does have a bond.
Okay, I just want to make sure it's not an ROR on that case, on that count, because that's not related to the new law.
That's correct, Your
All
Honor.
right, then so ordered.
You still have the 2.5 thousand bond. and the failure of your case. So,
All right, now I have some other files here. Let's go over them. All right, Mark Harity,
Behavior.
all right. Now, formerly, if there was a behavior, what we used to do is appoint the Office of the Public Defender. I'd like input from council.
Your Honor, if they're temporarily appointed, and then when he chooses to come to court, they can reset it for a plea at any point in the future.
All right, then let's reset. All right, now, Kevin Clayton,
Refusal.
Was there a refusal yesterday? Your Honor, this is the second refusal. We request that it not be reset again.
all right, then I think it would be appropriate to appoint the Office of the Public Defender in regard to this case.
And Your Honor, we'll waive his appearance.
All right. Now yes, reset. Let's go with IA.
I'm sorry, Your Honor, did you reset that? Or he waived his appearance by 2 days refusing?
It would be reset in court, and the Office of the Public Defender would be appointed. All right, and the next file would be that of aggravated assault with a deadly weapon without intent to kill. Michael Todd, and no bond. And we have also a probation violation. Willis, and $500 bond in regard to that. Let's see. So we've got case ending number 9608, Division 12, no bond, and then driving while license suspended. Bond, $500, Division A.
Right, and you're being held no bond on a BOP. You're not entitled to a bond on BOPs. So, bond out on anything. Because you're still in the same year you're gonna be.
And, let's see, probation violation, case 17 CF 11679, Division 22, no bond.
Okay, sir. Like I said, you got a bond and the other one, you don't want a bond right now. All right, for now, it sounds to me it's okay. All right, your turn. There's no BOPs in there.
All right, as to Mr. Todd,
Go. He's not done.
all right, your name, sir?
Michael Todd.
All right, sir, you have a set of charges here on which you're in a no bond status. And then operating while driver's license suspended, canceled, or revoked. $500.
Yeah. 500, and then you also have bonds. But if you don't get your VOP result in 7 days when you go to court, you're gonna get a court date in front of your probation judge downtown. Okay.
And then in another case, probation violation, no bond, division 22. Now, sir, do you want the Office of the Public Defender appointed?
Yes.
All right, the Public Defender's Office is appointed. We have Division 12 on the ag assault.
On the ag assault, Your Honor, we'd ask for no contact with the victim, no weapons, no firearms.
All right, so ordered. And then we've got another, Willis Fund, $500, Division A. Then, probation violation, no bond, Division 22, case, it's like 17 CF 11679. All right, so you qualify for appointed counsel. So you want to have a lawyer appointed for you, is that correct?
I don't understand.
Do you want me to appoint a lawyer to represent you in regard to these charges?
Yes.
Office of Public Defender is appointed. We have Division 12, Division A, Division 22. All right, now, it appears the cases involved are 17 CF 11679, Division 10, 19 CP 807, 8A, 19 CF 9608, and States Division 10.
What's it? Are you gonna be my public defender?
All right, then, I mean, guys, we have no 33-day motions to cover, so,
Your Honor, we would note that I believe he is entitled to a bond in both of his aggravated assault with a deadly weapon charges. And this is Michael Todd, case number 2019 CF 9608. I understand he is being held no bond on the VOP, but we'd ask for bond to be set as to that case. This is a third-degree felony, Your Honor. And while it is normally set no bond, it is set no bond until seen by a first appearance judge, according to the bail schedule.
all right, and any input, response from the state?
We asked for a $3,500 bond.
Say again?
We'd ask for a $3,500 bond.
Your Honor, under the bail schedule, a felony in the third degree is set between $1,000 and $2,500. We'd ask for a $2,500 bond.
All right,
As to count one and subsidiary as to count two.
so ordered.
Okay. That just sets bond. You're not bonding on either way. Good luck, sir. A subsidiary would be 150.
All right, that would appear to be all we have for session 1. How long would council request before we call session 2?
State request 45 minutes.
You said 45 minutes
Yes, Your Honor.
and defense?
Your Honor, we would request we reconvene at 11:15. That's just over an hour. I need to review the cases, finish reviewing the cases, as well as speak to the defendants in the back who have not yet been brought
1
up.
hour, would please announce their names for the record.
Kathy Kennedy Swanson on behalf of the Office of the State Attorney.
Cody Jordan with the Public Defender's Office.
All right, the first case is that of Derek Akers. Your name, sir?
Derek Akers.
All right, now, Mr. Akers, you've got a case here involving an allegation of possession of cocaine. The bond is $1,000. And I have reviewed the affidavit, probable cause exists. Now, you have filled out this application for criminal indigent status, and according to the requirements, you do not qualify for appointment of the attorney, public defender or otherwise, that would be able to represent you. So you would need, at this time, I would advise you, you would need to hire an attorney to represent you if you want one now. In regard to this, any comments or observations on the part of the public defender?
No, you're-
All right, now hopefully the court reporter can hear me.
No, Your Honor, I have no comments. I just wanted to speak with him briefly.
All right. Then, at this time, sir, let's see. Let's reset this for determination of counsel. Any other suggestions or remarks in regard to that situation?
No, Your Honor.
You don't have an attorney for that?
All right, reset.
Discuss it. No. You need to get your own attorney. You have 2 cases and you're being held no bond.
I thought you did toga on both cases.
Say-
To get an attorney on both cases.
Because I think there was a passenger. No, you were the passenger.
Wait.
Another passenger and the driver. So,
All right. I didn't go far enough. Yes, violation of probation, no bond. Battery with 1 prior. And that's Division 19.
you're going to see the judge in 17 days and it'll be okay.
Okay, so we can just.
Certainly, if he's in, you'll have to-
All right, sir, your name, please?
Byron Andrew Lawson.
All right, sir, you've got a charge here of possession of cocaine on which your bond at this time is set at $1,000. And I need to look further here. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
All right, the Office of the Public Defender is appointed, Division 10.
I'm sorry, sir, this is Byron Lawson.
No, this is, this file is that of Byron Andrew. All right, the affidavit lists the defendant as Edwin Cruz.
Mr. Cruz bonded, Your Honor.
And that was the possession of cocaine.
All right. Then the next case I have here, cases rather, are those of Byron Lawson. Is that you, sir?
Yes, sir.
All right, sir. You've got an application for criminal indigent status, and in regard to that, the Office of the Public Defender is hereby appointed. Now, we have Division 14 in regard to the first case, grand theft, burglary tools, trespass, and so forth. and there was a warrant issued, your total bond in regard to that first case is $6,000 in total, and then there is another case, here it is. Possession of cocaine with intent to sell or deliver, possession of paraphernalia resisting an officer without violence. On that set of charges, there's $15,000 bond plus $500 plus $500. So a total of $16,000 in regard to that Division 16 case. So the public defenders appointed, we have Divisions 14 and 16.
I know, it's ridiculous. This is a 22,000.
Your name, please?
Harrison Stevens.
All right, sir, you've got a set of charges here. Carrying concealed firearm, bond $2,500. Possession of cannabis, bond $150. Possession of controlled substance, bond what?
Your Honor, this is,
What?
I believe that is the other case that is a Spanish? Yes.
All right, reset then. All right, Harrison Stevens.
Yes, sir.
All right, sir, you've got a couple of cases here. One is possession of a weapon or ammunition by a convicted felon. Bond is $4,000 in regard to that. Then another case involving knowingly driving while license suspended or revoked, bond $500 in Division A. So Division 10 on the first case. Now, sir, do you want me to appoint a lawyer for you?
Yes, sir.
All right, Office of the Public Defender is appointed at this time.
Your Honor, we ask for no weapons, no firearms on the felony, and then on the driving while license suspended, bond be $100 as a subsidiary.
All right, on the
Means you can't have any weapons.
driving while license suspended case, it'd be $100 total bond. And possession of weapon or ammunition by a convicted felon, in addition to the bond, there would be other requirements that you possess no weapon or ammunition.
Yes, sir.
So you have, again, Divisions 10 and A.
Talk to your attorney. Come on, sir.
Mr. Velazquez bonded, Your Honor. The next defendant, Michael Velazquez, bonded.
All right, the next file I have here is that of Kenton Young.
Yes, Your Honor.
All right, sir, your name, please.
Kenton Young.
All right, sir, a couple of matters here. We've got a case involving battery on a law enforcement officer, bond $2,500. Resisting an officer with violence, bond $1,000. resisting an officer without violence, bond $500, and possession of cannabis, bond $250.
Your Honor, we'd ask those bonds be treated as subsidiary charges, leaving the bond set in count 1 at $2,500. The bond in count 2 at subsidiary count would be $150. Count 3 is a misdemeanor, would be $100, and count 4 as a misdemeanor would be $100.
All right. Any objection on the part of the defense?
No, Your Honor.
All right, then it would be so ordered. Bond 2,501 on count 1, 150 on count 2, and $100 on counts 3 and 4. And now, sir,
Yes, sir.
do you want me to appoint a lawyer for you?
Yes, sir.
Office of the Public Defender is appointed, and that is, looks like Division 14.
Terrible, man. Oh my God. Good luck, sir.
All right, next file I have is that of Jawan Williams.
Yes, sir.
All right, sir, you've got a failure to appear warrant with a bond in the amount of $500. Did you previously have a lawyer appointed for you, sir?
No.
All right. Now, on this case, does the public defender have any indication of previous appointment?
No, Your Honor, we were not appointed to this case previously, and this is a failure to appear at arraignment. I'm guessing that was the time and place an attorney would have been appointed.
Your Honor, the state conveyed an offer of a withhold credit for time served.
Withhold means it doesn't count as a conviction? For the time served, you get out right away. Your Honor, he does wish to accept the offer. I would note that the public defender has not been appointed to this case. He will enter an offer, a plea of no contest.
All right, public defender appointed for purposes of this proceeding. And now, state again?
A withhold credit for time served.
And is that offer accepted by the defense?
Yes, Your Honor, and we will enter a plea of no contest.
All right, then there would be a withholding of adjudication. The accused has entered this case on that basis. And let's see, we have 2 days, credit for 2 days, time served, adjudication withheld, and court costs would be, All right, $273 in court costs payable within 1 year.
Okay.
Look, sir.
All right, thank you, Your Honor.
All right, sir, your name, please?
David Porter, sir.
All right, Mr. Porter, you've got a violation of driver's license restrictions, driving while your business purposes only provision or requirement of your driver's license
Yes,
has
sir.
been allegedly violated. Now, need to look at one other thing. Yes. All right. Now, sir, I have no application for criminal indigent status.
Do you want an attorney appointed to this case, or are you going to get your own?
I thought I was.
Is there any
Yeah.
offer?
Is he bonded out right now? One person. Yeah, but they haven't received it.
My father had made bond, and I already confirmed that with him downstairs on the phone.
Do you want an attorney appointed to the case? Your Honor, he does wish to have the public defender appointed to this case. He had anticipated that he would be bonding out before this hearing, which is why he had not filled out a form.
All right, and for the record, any objection by the state?
No, Your Honor.
All right, so ordered by, rather, appointed the Office of the Public Defender in regard to this case. Now, any further input from the state?
We conveyed an offer of time served, Your Honor. Or Mr. Porter.
Yes, ma'am.
This would be an adjudication credit time, sir. You'd get out today. Sounds like you're down to the very first one.
Okay, violation of driver's license restrictions, and it's David
That's probably what it was.
Porter.
Well, it's up to you.
What's up to you? I'm sorry, sir.
Okay, so right now, the offer.
Say again? All right, now, sir, if you wish to accept that offer, there would be an adjudication of guilt, an offer of 1 day credit for a 1 day time served, $306 in court costs payable within 1 year.
Your Honor, after speaking with my client, he does wish to accept the offer and enter a plea of no contest.
All right? Then that penalty is imposed, and that is Division A.
Okay, so the case is over.
All right, Lawrence Jason is the next file. Say again? Yeah, yeah. It was, I think, Dave. Hmm? Yeah. All right, the next file is that of Jason Lawrence Simmons. Is that you, sir?
Yes, sir.
All right, sir. Let me look here. You've got a charge here of driving under the influence of alcohol or controlled substances, your bond is $500. Do you want me to appoint a lawyer for you, sir?
Yes, please.
The Office of the Public Defender is appointed. That's Division A.
State will request in the out on bond 18 CF 15489 that bond be revoked and he be held at no bond. The state has filed on that case, and that case has a court date on pretrial on 7/16 in Judge Kest's decision.
Your Honor, we believe that case will be resolved shortly in favor of the defendant. We would also note that the charges are unrelated to the charges he is currently facing today, and he has no priors, no prior convictions. Oh, wait, let me just make sure that you give me an updated sheet. That is correct. No prior convictions in the state of Florida or out of state, no juvenile convictions either. We would request that no action be taken. He does have a private attorney in the out on bond case. The case number for the out on bond case is 2018 CF 1548900. I think it's just 15489.
All right, well, the court is inclined to grant that request and enter an order accordingly.
15489, and that's a 2018 felony case. We're asking that he take no action.
All right, and state have any input as
We
to...
request it be revoked, Your Honor, and he be held at no bond.
All right, I think that's appropriate, would be so ordered.
And what is the bond set in this current case?
$500.
You're being held no bond. Don't bond out of this case because you won't get any game time where you're being held. You need to contact your attorney as soon as possible to let him know. You might be able to, you can file a motion with the court to end and get a bond set in that case, sorry.
All right, now the, excuse me, the next file I have is that of Sequilin Drummer.
Sakalen.
All right, ma'am, you have a charge of battery. Your bond is $1,000.
All right.
With no victim contact. Would you request that a lawyer be appointed for you now?
I'm sorry.
Do you want a lawyer?
No. Yes.
All right. So the Office of the Public Defender is appointed, Division A, and no contact with the alleged victim, Jasaria Wilkes. All right, the next file is that of Jonathan Jones. Is that you, sir?
Yes, sir.
All right, sir, you have a set of charges here. Disorderly intoxication in a public place causing a disturbance, and bond is $500. Resisting or obstructing an officer without violence, bond set at $500 at this moment. Now, sir, do you want me to appoint a lawyer for you?
No.
Do you want me to appoint a lawyer for you?
Your Honor, he did say no.
Yeah, no.
All right,
We would request as a friend of the court simply that Your Honor reduce the count two to his subsidiary charge and reduce the bond to $100.
all right, that would be granted. So the bond on count two would be $100.
Okay. $600,
And
we got 500.
public defender appointed.
He doesn't want to, he does not wish for a public.
Excuse me.
So,
All right,
$600.
the order appointing the public defender is vacated and set aside at this time.
No, just talk to downstairs.
All right, the next file is that of Damian Mashad. Is that you, sir?
Yes, sir, it is.
All right. Sir, you've got a charge of disorderly intoxication, and probable cause does exist. Do you want me to appoint a lawyer for you, sir?
No, sir, I don't need a lawyer.
All right. Well, you understand that you're entitled to represent yourself if you wish. You can hire a lawyer, or you do qualify for appointment of a lawyer from the public defender's office. So, realizing that, do you want a lawyer appointed to represent you?
No, sir.
All right. And that would be all for today then.
Does he qualify for pretrial release? Your Honor, as a friend of the court, we would request that he be released pretrial release instead of a bond.
All right, and state,
No objection.
so ordered.
So you don't have to pay a bond, but you gotta keep in contact with him. Good luck, sir.
All right, the next file I have is that of Jeannie Rogers.
She's behavior, Your Honor.
Say again?
She's behavior.
All right, reset. All right, next case is that of Terrell Brackens. Is that you, man?
Yes, sir.
Okay. You have a case out of Sarasota County. Bonds were set there in the amount of $15,000, count one, $2,000, count two, controlled substance, DUI, it looks like. So you would be transferred to Sarasota County to answer to the charges there. So there would be a hold place in regard to these charges for extradition to Sarasota County.
Okay, man, 72 hours. Good luck. Step back. Come down here.
All right, next case is that of Vincent Betton.
Medical, Your Honor. Medical.
Okay, reset. All right, Curtis Young.
Yes, sir.
All right, sir, Mr. Young, you've got a set of charges here, disorderly conduct, and the other allegation is state misdemeanors. All right, for, all right. It says here in the affidavit that you're charged with resisting without violence for your attempt to defeat the officer's attempts at arresting you. So, in any event, you do qualify for appointment of the office of the public defender. Sir, do you want me to appoint a lawyer for you at this time?
Sir.
Say again?
No, sir.
All right, I don't know if there's any offer from the state.
There is not, Your Honor.
Okay, so your total bonds are $350. Probable cause exists. No attorney is appointed at this time.
Your Honor, I spoke with the state earlier, and I believe they had no objection to him being released on his own recognizance. He does have no prior convictions.
All right, and state for the record.
And one moment, Your Honor. No objection, Your Honor.
All right,
Get an attorney.
so ordered then. All right, anything else?
You are on.
Nothing, Your Honor.
If there's nothing further, then court would be in recess, subject to call.